Good afternoon, everyone. Thank you so much for being here. My name is Kelly Crum, Brand and Content Manager for Maryland Realtors. I want to welcome you all to our Legal Hot Topics webinar. Today, we have with us our Maryland Realtors legal associates, Cleo Pappas, Taylor Kitzmiller, and Ting Dong. Together, they will dive into the 2026 legal hot topics that they've been seeing, EMDs, home inspections, and conversations around AI. We do encourage your questions and we look forward to answering them. Please post your questions in the Q&A box below at the bottom of your Zoom screen. And with that, I will turn it over to Ting. Ting, take it away.
Thanks, Kelly. Hi, everyone. This is, like Kelly said, the Legal Hot Topics webinar by the Maryland Realtors legal team. And on our team, we have Kim Link. She is the Director of Legal Affairs. We have Cleo Pappas. She is Senior Associate Counsel. We have Taylor Kitzmiller, Associate Counsel. My name is Ting, and I am also Associate Counsel. And we also have Laura Fitzgerald, our Legal Affairs Administrator. Before we begin with this webinar, we want to remind you of your member benefit, the legal hotline. So, the screen should be the third screen, the slides.
Hold on one second. For some
Okay,
reason, it is not working.
okay, gotcha.
You can still talk about that, Ting.
Okay, okay. Well, we're figuring out the technology issue. So we are available on Monday, Wednesdays, and Fridays from 10 to 12, and then in the afternoon from 2 to 4 to answer all your legal questions. And if you have a burning question outside of hotline hours, you can always submit it to our website at mdrealtor.org. And now for this webinar, we will go over several hot topics. And next slide, please. Thank you. So that is the earnest money deposits. We will also talk about home inspections, AI, and we will have time at the end for questions as well. And Cleo will start with earnest money deposits.
Thank you. Thank you, everybody, for being here. Happy New Year. So my topic of discussion this afternoon is earnest money deposits. And it is a hot topic. I should go back and look to see how many in just this month alone, since we came back from the holidays, how many EMD questions our team has received on the hotline, because it is a daily occurrence. And there is confusion from the licensees, and certainly there's always questions from the clients regarding, I want my money, I want to keep my money, where's my EMD, what do I do with this, what's the next steps, etc. So we want to delve into this to make it clear for everybody involved regarding earnest money deposits. First and foremost, earnest money deposits are not actually legally required to form a contract in the state of Maryland for real estate purposes. If it is proffered by the buyer and accepted by the seller, it has to be good. But there's no actual requirement to include it in an offer or in a contract. And the question is, well, what is it? Well, first, once there is an earnest money deposit in a contract, both the buyer and the seller have an equitable interest in those funds. But what is it really? Why have it at all? And frankly, I was in the business for 20 plus years, since like 2004, and I remember it being on the contract forms back then. So what is it really? Is it really the perception of buyer's seriousness, or how much money they have, or how much money they're willing to keep in limbo to show the seller they really want the property? Is it something the sellers believe they can hold the buyer into the contract and not let them go, or the buyer just won't walk away easily if they have some money in limbo that they may not get, or the seller may get, if the buyer doesn't complete the contract all the way to the settlement date? Or if the buyer uses one of their contingencies, can the seller hold it back from the buyer? Not really sure how it's perceived nowadays, but it's not a down payment, and it's unclear as to whether or not the buyer's seriousness is really at stake with however much money they decide to put down an earnest money deposit. Is a buyer going to actually not walk away and stay in the contract and purchase a house they don't really want to buy just because they may not get the earnest money deposit back? I'm not sure. But keep in mind, it doesn't actually transfer ownership. The escrow holder, whether it's buyer's brokerage or a title company or an escrow holder, it could be anybody, frankly, it could be an attorney. It doesn't transfer the ownership. The escrow holder is just kind of overseeing the money to make sure it gets to where it's supposed to go ultimately. How do we explain this to clients? We were just on the legal and legislative class, a CE webinar, CE class online with Kim Link. And one of the questions we had from one of the class attendees was, can you explain how we explain this to buyers? Well, that's pretty much up to you and to your sellers. And definitely speak to your broker manager about it if you have a lot of questions as to why there is an EMD at all and why a buyer should proffer it. But it needs to be explained up front. Certainly when there's a buyer agency consultation or a listing consultation and you start to speak about what an EMD is and what to consider it, and definitely by the time you write an offer or get an offer, to explain what it means, because buyers don't automatically get it back if they don't get to settlement or they exercise one of their rights under the contingencies or they're in default or vice versa with the seller. And the sellers don't control it or possess it 99% of the time. So they can't keep it in their pockets if they think the buyer has wasted their time or validly terminated the contract because of one of the contingencies, or even if the buyer was in default, the seller doesn't automatically get it back or get it or keep it because it's not in their pocket. So keep in mind for the seller, if a buyer in fact is in default, it's not liquidated damages to the seller. And we always refer back to not only the deposit and default paragraphs in the contract, but those are things that you should read with your clients in advance so that they can understand what it means and what happens in case this does not go to settlement, what occurs with this deposit. It's not an automatic buyer gets it back or seller gets it. And deposits don't simply get kept. The escrow holder, whether the buyer brokerage or the title company in many instances, don't have a chance to just keep it. The escrow holder has to abide by the law, and you can find the law very simply put in the release of deposit agreement form. So if we can go to the next slide. And we apologize. Laura's in charge of the slide deck because there's several of us handling the slides at the same time, so it was easier for her to do it. So what is the EMD? What's the release of deposit? It's a separate from contract release. Years ago, they used to be on the same form, but a few years ago, it was separated out. Now you must first actually have termination of the contract before the EMD can be considered to be provided either to the buyer or to the seller. So two separate documents. The contract either has to be terminated by unilateral notice by the buyer or seller, or by a mutual release of contract by both parties where they agree in advance they're just walking away. You can still have one of those terminations of contract, but still have a dispute of the deposit. It's not always one and the same. So make sure you have the right termination if that occurs, and then you ask the question, all right, who's getting the deposit? How is this going to be distributed? Keep in mind, there's no such thing as an expired contract, or the terminology every agent I've heard use for 20 years is out of contract, we're out of contract. No, you actually still have a contract. It still exists, even if the settlement date has come and gone. If the parties are acting as if they're under contract or there's no termination in writing, there's no termination. So please make sure you do things properly. And if you ever have questions, review all your documentation and correspondence with your broker manager to make sure you know what you're doing for your client and your client knows where in the process they are in that contract. So, next slide. It's a smaller version, but hopefully you've all seen it in our forms document or one of your e-signing programs, what the release of deposit agreement looks like. It is one page. I kind of call it the mutual release of deposit because that is the quickest and easiest way to actually get the deposit resolved. Without both the buyer and seller agreeing in writing as to who gets the deposit, which is the top half of the document, then you have a dispute of the earnest money deposit, who gets it. The escrow holder can't just decide. So Could it be that they negotiate that buyer and seller get part of it each? Yes, that can be done. It can be split, but that takes some negotiations and good communication skills. But generally speaking, when we look at this form, I'm going to hedge my guesses here. I would say probably 9 out of 10 times the buyer submits this to say, hey, I want my deposit back and release this back to me because it's my money. And when there is a dispute, it's because the seller does not wish to release the funds back to the deposit and basically says, I'm not going to do that. When that occurs, we then have to go through a process. What is going to occur now and what should the escrow holder do? Well, that all depends on why the contract was terminated and the reasoning behind it. So let's go to the next slide. I may switch back and forth. So what are the procedures for the contingencies? You want to review the box on the release of deposit form. It very specifically states, and actually, Laura, can you go back to the previous slide? I'm sorry. Thank you. So I have two screens, so I apologize if I'm not looking directly at you all. So if you'll notice, the very top half says release a deposit agreement. Then sort of a third way down, it says notice. If buyer terminates the contract of sale pursuant to a contingency listed herein and seller does not execute this release of deposit agreement, the following release of deposit procedure shall apply. We call this the contingencies in the box. These contingencies are listed here. The one you'll notice that is missing is the financing contingency. The legislature currently is working on it, I suppose, for lack of a better word. I don't know if it will be included for next year or not. That remains to be seen. But for right now, these are the contingencies we're talking about. If the buyer checks off the box that one of these contingencies is the reasoning for terminating the contract, then the procedure must be followed. The buyer may request the return of the deposit by providing the holder of the deposit, the escrow holder or the escrow agent, and the seller with a written notice. And this form itself is considered the written notice of the request. Hey, I'm submitting this. This is X number of dollars I put into escrow. I've terminated based on one of these contingencies in this box. Please provide me my money. Please seller sign. If the seller wishes to protest the request, i.e. they don't want the going back automatically to the buyer upon this request, the seller has an affirmative actual duty. They have to act, and it says must. Within 10 days after receiving the request, meaning this form, they must provide the escrow agent and the buyer with a notarized request for mediation relating to the distribution of the deposit, meaning the seller has to go, I got this form. I don't want to let the buyer have their money back. I'm going to get online. I'm going to file for mediation, put the dispute of deposit as the reason, and I'm going to send the escrow holder and the buyer a copy of the fact that I'm protesting this request and kiboshing it basically with the copy of a notarized request, this copy that I've already gone through the process for to request the mediation, and I'm sending it to them within 10 days of getting this request. That's the affirmative duty. It doesn't mean that mediation occurs within 10 days. It just means the seller has done the actual trying to get the mediation going and saying, I'm protesting and here's everything. It's very specific. If the seller does not do this and does not deliver a notarized written request to the escrow agent and the buyer within 10 days after getting this release of deposit request, within 30 days of that initial request, the escrow holder shall, basically a must, distribute the deposit to buyer and seller and give both the buyer and seller notification of such. If somehow the seller does deliver a notarized request for mediation to the escrow holder and the buyer within 10 days, the escrow agent shall hold the deposit until mediation agreement has an agreement between the parties to authorize the distribution. Or at that point, if there's no agreement at mediation between the parties, then the escrow agent can file an interpleader in court, which is a legal action. It's a form they have to fill out. Actually, not fill out, they have to create it. and file it as a motion of interpleader. Hey, court, you guys decide what to do with this money. These two parties can't make up their minds, and I don't want to have the money anymore because they're in dispute. So if both parties don't execute the release of deposit following the termination, not listed as a contingency in this box up here, then the old procedure continues, meaning the escrow holder will file a 30-day letter stating they wish to give the deposit back to the buyer if they so decide that's who should get it back, or they can also file an interpleader. So it's not an automatic process for either party. If we can go to 8, yeah, there it is. Thank you very much. So keep in mind, there's the box, there's not the box, the financing. There is no actual process specifically for sellers to get the money or keep the money. In fact, just a release of deposit, if the seller makes the request, and they can fill out the form as well and say, you know, I think the buyer's in default or whatever reasoning they have, and they submit a release of deposit agreement after a termination of contract to say, hey, X number of dollars that the escrow holder has, I want that. They can file that form and they can then file for mediation. There's no requirement to file a notarized letter requesting mediation or sending stuff up. They just have to file for mediation, or you can request the escrow holder to file an interpleader. A lot of times escrow holders don't want to do that because the process is long and costly and it goes through the court system. So keep that in mind. And you want to explain to the buyers and to the sellers what having an EMD in limbo may mean. It may not be too much for the sellers because it wasn't in their pockets in the first place, but for those buyers who need those funds to purchase the next house, if this contract doesn't go all the way through to the settlement and it remains in limbo, you may have a problem where a buyer can't buy their next house because they don't have those funds. So you want to make sure you explain clearly enough before they enter into a contract with the offer of that EMD that they know what they're doing and that the process of getting the money back is not super easy or super quick. It could be, depends on how the parties react to each other, but the process is not an immediate thing. Let's go to 9. The procedures I just mentioned very quickly regarding those contingencies that are not in the box. And so the options there are the parties get to sign the mutual release of deposit, which requires signatures from both parties, the 30-day letter from the escrow holder, mediation, or interpleader. But with mediation, both parties need to come to the table and both parties will have to pay for it. An interpleader, the escrow holder pays for it. And that can be expensive and that can be very long in the process because you're talking about the court system. So number 10 for slide. So again, we reiterate this a lot on the legal hotline. And what we do is literally get the document and read it with the agent step by step because it can sound complicated, but if you follow it, it does make sense. It's just not immediate. So keep in mind, release of deposit must be signed by both parties, or the buyer makes the request and seller refuses to sign the release of deposit, and they're trying to prevent the buyer from receiving the EMD. And the seller must, within those 10 days of receiving the buyer's request, provide the escrow holder with a notarized written request for mediation and the copy of that request. And if the escrow holder does not receive the seller's mediation request and the copy notarized, etc., within 10 days, the escrow holder must release the EMD to the buyer within 30 days of receiving the buyer's request. So I had a question this last week from an agent asking us to put something in writing to demand the title company do something. And unfortunately, neither of the agents nor Maryland Realtors can force a title company to do anything. It is having clear communications, discussions, and ensuring that your client has done what they're supposed to do under the law to make sure the deposit gets released appropriately. In number 11, best practices is definitely communicate early with your clients about what the EMD is and how it's returned before any issues arise. and verify the deposit with the broker or title company. Over the years, I've seen this question as well. What happens if there is a dispute in the contract, it doesn't go all the way through, it gets terminated, and then they discover the EMD wasn't actually provided or cleared, etc. It is your duty as the buyer agent, if there's in fact an escrow agreement that needs to be signed between the parties, that should be signed as quickly as possible upon contract formation. If it goes to the buyer brokerage, ensure, and even the title company, ensure that it's been provided. Double check that it's been cleared. And certainly as a listing agent, you want to do your fiduciary duties to your seller as well. Ensure it was deposited, ensure it was cleared, make sure it's there and accounted for, because that will save a lot of trouble. The question as to whether or not escrow agreements that have not been signed, and those are usually with third parties like the title companies, it is their duty to make sure those documents are signed as well. And unfortunately, that can cause confusion and problems later on if in fact there's no escrow agreement, and then sometimes lawyers get involved. But we want to make sure that everybody's clear. One of the things I say all the time with any questions agents have, let's read the document. So please make sure you read the document carefully so that you know exactly what the procedure is, what you're supposed to do, and then we'll read it together if you have further questions. Now I will hand over, unless there are questions in the chat that I'm not aware of, to Taylor to talk about home inspections.
All righty. Thanks, Cleo. So my portion of the presentation is to go over the home inspections, the property inspections addendum / notice form. And really what I'm going to do is touch on some ways that this form is improperly used by our members. And number one, and number two, we're going to go through what is the proper procedure for if a buyer and seller agree to allow inspections to be performed. How are those inspection reports provided to the seller? What's the time frame for a response from the seller, counteroffers, etc. The first thing we start with here is for informational purposes only. This phrase, at least how it's been reported to us, is used sometimes by agents, written in by agents on the property inspections addendum. Let's make clear that the property inspections addendum, the agreement, is for the buyer and seller to agree to allow XYZ inspections to be performed, and it states what the buyer's rights are. Those rights being, after the inspections are performed, that buyer has the right to terminate without providing a reason why, or the buyer can make a request for repairs to be made or seller credits to be provided. So it specifically is arranged in a way that the inspections are not just for informational purposes only. So by writing in that statement, it likely contradicts the rest of the form, which could lead to issues. What is enforceable in that agreement, number one. And number two, agents and brokers are prohibited from the unauthorized practice of law. So an agent or a broker writing in contractual language like for informational purposes only could potentially be considered the unauthorized practice of law. Now, if your client wants to write something in, that's up to them. I think the best practice would be to discourage them from drafting their own contractual language and recommend that they reach out to their own attorney. But agents and brokers should not be writing in contractual language like for informational purposes only. Actually, we had a proposal that was presented to our statewide forms committee somewhat recently to add in an option to the property inspections addendum for inspections to be for informational purposes only. Statewide forms committee discussed that proposal and ultimately decided against adding in that type of an option. Moving on to the second bullet point here, what does as is really mean? So typically when agents say as is, they're meaning the seller's not going to make repairs to the property. But our contract, the way it is set up, our residential contract of sale, the way it's arranged is it is on its face an as is contract, meaning that the only way that it's going to change from an as-is contract to a contract that is subject to a contingency is if the parties agree to add a contingency like a property inspections addendum. Um, Paragraph 25 explains this essentially, that the contract is an as-is contract. However, even if the contract is as is, the seller would be required to provide that disclosure disclaimer statement unless they fall under one of the exemptions. And also that seller is required to disclose all latent defects in the property, and agents and brokers are required to disclose all material facts within the property. All right, Laura, we can go to the next slide. Okay, so the inspection contingency. It states that the buyer has the right to conduct the agreed upon inspections within a certain number of days, which is established as that inspection deadline, at the buyer's expense, and that deadline is measured from the date of contract acceptance. I want to touch on the agreed upon inspections. So on the property inspections addendum, we have a list of defined inspections. So we have structural, mechanical, mold, radon, I believe chimney is on there, and there's a couple other that are actually listed out. And we also have a section underneath for other inspections not specifically listed to be potentially added and agreed to by the buyer and the seller. So the inspections that should not be included in the property inspections addendum and should be agreed to in separate addenda are the water quality, water yield, and on-site sewage disposal test addenda. It specifically states that in the property inspections addendum that if the parties are going to agree to those types of inspections, they should use the separate addenda. Another thing that's reported to us on the hotline is we have sometimes agents call in and complain about a buyer inserting in the other section, inserting language that essentially says any other inspections that are recommended by the inspector, and whether or not that's enforceable. Likely it is enforceable because it's submitted by the buyer and they're saying we want inspections to be performed that are recommended by the inspector. So if a seller agrees to that term, they're kind of opening Pandora's box where that inspector could recommend XYZ additional inspections, and since you agreed to that provision, it's likely that the buyer can perform those inspections. So it's clearly a more preferential term, a provision for the buyer side, and not so preferential to the seller side. So that's where you need to keep an eye out if you're representing a seller and they don't want to agree to that uncertainty where they could have to allow that buyer to do additional inspections, then they shouldn't agree to a term like that. Let's see. The seller must provide reasonable access to the property in order to have those inspections to be performed, and have utilities on for those inspections. All right, we can go to the next slide, Laura. Okay, so let's just say the buyer and seller have agreed to allow certain inspections to be performed. What process takes place after that? Before we get into the specific, time frame for responses and what the buyer and seller have to do, these listed here, these 1 and 2, are what the buyer's rights are. So as I touched on earlier, the buyer has the right, if they want to unilaterally terminate the contract after performing those inspections. They also are not required to specify a certain reason for why they are terminating. Or the buyer has the right to negotiate. And the buyer, if they want to negotiate for repairs to be performed or a seller credit to be provided, that buyer has to submit the inspection report to the seller, and the buyer can make one written request for repairs and or a seller credit. This is a question that we get somewhat often on the hotline. where a buyer submits the original request for repairs to be performed, and then a couple days go by, and then they submit an additional request with additional repairs to be performed. What happens there? What does the seller have to abide by? It is the first written request that the buyer submits. So if you're on the buyer side, you need to ensure that before you submit that written request for repairs or a seller credit, that it encompasses all of the repairs or credits that that buyer wants. Because if you follow up with an additional request, the seller does not have to recognize that request. The request has to include the inspection reports and any monetary credit that's provided from the seller to the buyer is subject to that lender approval. And I want to, that's fine. We can go to the next slide. Another thing that popped in my head is a question we get somewhat often on the hotline is, let's say buyer submitted or provided the inspection report to the seller, and the seller didn't agree to the repairs, and the contract falls through. The buyer and seller can't come to an agreement. Let's just say the buyer terminates, and then the seller relists the property. Well, the question is, does the seller have a seller slash listing agent have a duty to disclose material facts and or latent defects that are included in that inspection report? And the answer is yes. Licensees throughout the state of Maryland have a duty to disclose all material facts that they knew of or should have known about. So a material fact is anything a reasonable buyer would want to know before submitting an offer to purchase, something that could affect how much they offer for the property, for example. So if a listing agent is provided with an inspection report and that inspection report exposes material facts in the property, and that listing agent wants to relist the property and go with buyer number two, well, since that listing agent has the inspection report and that inspection report contains material facts, the listing agent has a duty to then disclose those material facts to any future buyers. All right, we can go to the next slide. Okay, so now we're going to get into what the actual process looks like. So after the buyer submits their written repair or credit request to the seller has a 5-day window to respond to that request in writing. And really, the seller has 3 options. The seller can, 1, agree to all the requests, whether it's making repairs or providing a seller credit. If that's the case, the contract continues. Both parties are happy. 2, the seller could agree to some of the requests, or 3, the seller's going to refuse all of the requests. For number 2 and 3, if that's what happens, the buyer has a 2-day window from receiving that response to either terminate the contract, waive the requested repairs or credits that the seller does not agree to, or the buyer can submit a counteroffer. And they're only going to submit a counteroffer if the seller does provide a response. What happens if the seller doesn't respond? So as we said, after the buyer submits the request, the seller has 5 days to respond. If the seller does not respond within those 5 days, the buyer has 2 days from the end of that 5th day, that deadline where the seller was supposed to respond. The buyer has 2 days to either terminate the contract or waive the requested repairs that the seller has not responded to. Okay, next slide, please. All right, but what if the buyer submits a counteroffer? Maybe the seller submits another counteroffer. There could be an unlimited string of back and forth between the buyer and the seller. If a counteroffer is made, the other party has 2 additional days from the delivery of that counteroffer to respond. What's very important to know is if a party does not timely respond within those 2 days to a counteroffer, it constitutes that party's automatic acceptance of the counteroffer. So if buyer and seller have been going back and forth with counteroffers, and then buyer sends a counteroffer to that seller saying, I counter and I want you only to repair the pool liner, let's just say. The seller has 2 days to respond. If the seller does not respond within those 2 days, it constitutes their automatic acceptance. And now, seller, you have to repair that pool liner. All right, next slide, please. All right, I believe this is the last slide, just kind of wrapping up property inspections and some practice tips. If the seller agrees to repairs or credits, those, well, I guess we should say if they just agree to repairs, those repairs must be completed before settlement. The seller must provide receipts for that completed work to the buyer, and the buyer has the right to re-inspect the property to confirm that the repairs have been performed, number one, and performed in a quality workmanlike manner. The buyer's confirmation right ensures that the agreed upon repairs are properly completed before that settlement date. And some practice tips here, just to complete and verify that the repairs are made before settlement whenever that's possible. If you're on the buyer side, request a repair completion deadline that allows sufficient time for reinspection. Because if those repairs aren't completed until a day before settlement, it doesn't really give the buyer a lot of time to inspect that the repairs have been made prior to settlement. Require paid invoices by a specific date, and request copies of warranties or guarantees if they are available from licensed and insured contractors. And buyers can be specific about the contractor qualifications when they're needed. For example, it could be a contingency for the buyer that the electrical work be inspected and repaired by a proper electrician, not just, let's just say, a general contractor. All right, and that is all I'm going to touch on for the property inspections addendum, and I'll get to those questions in the Q&A. And I'll hand it over to Ting.
Thanks, Taylor. So now we're going to go over AI for realtors. And before we begin, we want to say, just making sure I'm unmuted. Okay. We want to say thank you to the Mississippi Association of Realtors for a recent article on this topic, and it has a lot of useful and helpful information. So now, AI, what is it? AI is man-made intelligence that can mimic the problem-solving and decision-making capabilities of humans. AI is capable of recognizing speech, making decisions, identifying patterns, and solving problems as well. And AI is capable of doing these things through various methods like machine learning, deep learning, and natural language processing. So now, why are we talking about AI in a webinar for real estate? Well, real estate realtors are licensed professionals with fiduciary duties to their clients, and as such must exercise judgment and provide advice for the best interests of their client. So as licensees, you are fully accountable for making sure that AI usage is in compliance with the laws, regulations, and ethics that govern your licenses. If you use AI-generated material with mistakes in it, whether or not that mistake is intentional, it can cause harm to consumers and may expose you to regulatory penalties or compliance violations. And for this reason, on the next slide, we have some considerations for AI use. The first on the list is accuracy and reliability. AI is not 100% accurate. This means if you use information from an AI source, you need to make sure to double check where the AI got its sources from. This also means you should double check AI logic. Also, you should take caution and not ask AI for legal advice. Real estate licensees should seek advice on what to do from their brokers, and brokers should seek competent counsel. Next on the list is fair housing compliance. So again, AI is not always accurate, and therefore you should be very careful with asking AI if you're in compliance with fair housing laws. Another thing is you should be careful with just copying and pasting AI-generated marketing material. For instance, if you ask AI to decorate a living room, sometimes AI will add an extra window in there. That's just one example. So next on the list is do not upload documents or confidential information. And this is so important because not all AI platforms will keep information you upload and the chat histories private. Next is Bright MLS compliance. So for Bright MLS, you want to make sure that the information you put for property description and pictures and any virtual staging are all accurate. And as such, it's good business practice to disclose whenever you used AI for virtual staging or for any marketing material videos. Next on the list is copyright. So according to an NAR video, currently under US copyright laws, works by AI are not protectable because a work must be authored by a human. But AI and copyright laws are likely to evolve over time, and this does not mean that using work that another licensee may have created using AI will not get you in trouble. So for brokers, and we can go to the next page. Next slide. Thank you. So for brokers, it's best to create a governance framework that takes into consideration AI. And this means thinking about who owns the AI-generated content for listings and advertisements, having AI use standards, providing an approved list of AI platforms and a list of platforms to avoid, and having discussions about who should review content created by AI in the brokerage, and also having privacy rules for clients' confidential information. Again, do not put the information into AI platforms. Also, you should consider disclosure of AI-generated images and content. And last on the list, errors and omissions coverage is recommended. And now we go to our last slide. Thank you. And we are open to questions.
We've had several in the chat, which I've attempted to answer some of them. A lot of them are pertaining to home inspections. Taylor, I don't know if you want to take a quick look to answer.
Yeah, I've
the big
been
ones.
answering some as we go. Yeah, here's a question from Jennifer. The one request for repairs is just for property inspections, i.e., the buyer can send separate requests for the on-site sewage disposal inspection, water quality, and water yield inspections since they have different deadlines. Yes. So the seller only having to respect the buyer's first request. That is specific to the inspections in the property inspections addendum. Those other three types of inspections could have different deadlines and different requests.
And when I look through some more, I'll add on to that because I just had a question on the hotline regarding that because there were structural mechanical requests and that had a different deadline. There was also well, water quality, septic, etc. And we looked at those forms, and in fact, with the deadline on those Maryland Realtor forms, it was that the buyer had to make the requests, if any, to seller to repair anything related to those items 5 days after receiving the results. So keep in communications with your clients to make sure everybody is on track for the deadlines and you're receiving back the results from those inspections in a timely fashion. You have a certain number of days to do the inspections, but the results and the requests have to go to the seller within 5 days per those documents once the buyer side has received the results. So just for best practices, if you're making your request for structural and mechanical sooner than the rest of those inspection timeframes are coming due, just let the other side know, hey, by the way, these are due now and we're still waiting for the results and we have 5 days from when we get them. As soon as we get them, we'll let you know. Again, communication is key when you're dealing with EMDs and inspection requests, reports, etc.
Taylor, do you want to answer some questions aloud since we have extra time?
Sure. Well, yeah, we can. We have a long list of written questions.
Okay. Well, that's what I mean. We can't take questions from the chat.
Oh yeah, I can do some from the chat. So one I was looking at from Brian, what if the material facts have been addressed, i.e. repaired or rectified? So if a material fact has been repaired or rectified, it's still considered a material fact that needs to be disclosed to a potential buyer. Now, an example that we've gone through in our ethics class is if there was a fire in the garage and let's say the walls needed to be replaced, that is a material fact. Even if the walls have been replaced, everything looks great, there's no current issue, it is still considered a material fact that would have to be disclosed. Now, when you disclose the material fact, you can certainly clarify that this was an issue, but we have taken steps XYZ to rectify that issue. Some of these questions are a little fact specific and complex. So I'm going to have to skip some of them. If I do skip your question, it's likely because it is a little complex. If that's the case, please feel free to call or write in to our legal hotline, and we can get you an answer.
Can I answer one?
Yeah, everybody can feel free to jump in. I'm looking through these.
So on the one question from the anonymous person, does the counter offer have to be on an addendum or is an email between agents acceptable? So emails between agents are not agreements between the parties. The parties generally have to sign off on what they're agreeing to. So yes, negotiations in a sense between agents because you're representing your clients can be discussed. Obviously, that's what the job is as a licensee. However, if there's going to be an agreement in place, it needs to be in writing by the parties themselves.
And do you want to take the question right underneath that from
Look.
Griselle? Because it kind of touches on it.
Oh, it's scrolling so fast, I just missed it.
Yep, it's most of the time I get a text back with the seller's response. Is this considered a legitimate response or only a signed response by the seller? Sorry.
Only a signed response by the seller is a real response. You get a text from the other side, and I know we get this question a lot regarding offers and acceptances, so I won't touch on that right now because that's a whole different topic. But in terms of negotiations for inspections, it still needs to be in writing by the parties.
If the buyer submits a request for repairs, do they give up the right to unilaterally terminate? If the requests are outside the scope of the inspection contingency, can the sellers accept? Oh, it's getting a little complicated. I'll just answer the first question here. If the buyer submits a request for repairs, do they give up the right to unilaterally terminate? Yes. The buyer, after repairs are performed, really has two options. Buyer can either terminate without specifying a reason, or they can send the inspection report and make the request. But if they send the inspection report and make their request for repairs to be made, they can't just automatically back out and terminate the contract.
As you read more, I'm going to answer the one question regarding, I'm still confused about EMD and its purpose. Please explain. Great question. I think it has developed in folklore that somehow the earnest money deposit keeps the buyer in contract or gives the seller an opportunity to get some money if the buyer defaults, or the more the better it is for the buyer to get their offer accepted. I'm not really sure of the ultimate purpose regarding earnest money deposit other than maybe qualifying their offer in some way to make the seller feel better, or make themselves feel better. It really is coming to the point of, and I've heard listing agents over the years say, I'm never going to let my seller accept an offer that doesn't have X% of an EMD, or it's too little, or I want more, or things like that. The purpose of the earnest money deposit was supposed to, in my day, I've heard, show that the buyer has some skin in the game. They're not going to just walk away. So, I think that's something you need to talk to your broker manager about and discuss when, how much, what's the best solution on explaining this to my buyers and sellers. Keep in mind also, if the concern is EMDs are going to remain in limbo for a while, and we're not really sure where the contract is headed, and both parties seem to think that they want to put some money as earnest money deposit or have the money in limbo for the seller, I would go back to our contract form on the first page. You can put some money now within X number of days, and then later on, you're allowed to add an additional earnest money deposit. It's all part of the negotiations, and it varies so widely depending on the circumstances for the buyer and how much money they have to even put down for earnest money deposit, or if they need it for a future property, if this one doesn't go all the way to settlement. Does it make the seller feel better? Again, this is all part of the contractual negotiations, and there's so many what ifs, and it all depended on both the buyers and the sellers and the type of property and the price, what the lender says. So, yeah, earnest money deposit is all we know is when there's a problem, there's a problem.
I would chime in there, Cleo, and say, and push back a little bit on whether the EMD really conveys the seriousness of a buyer, right? If a seller has two identical offers and one has an EMD that's higher than the others, does that really mean that buyer's more serious? I know Chuck has said before, if you've ever known a buyer who went through with the purchase of a home that they didn't want because they didn't want to lose their deposit, right? So I think it's important to really think about and communicate properly with your clients what an EMD is and is not. I think, we'd like to challenge the long held beliefs by some realtors of what it means, and maybe start thinking, does it really mean that or not? And how does that apply to your particular clients and their best interests?
Another question from Matthew, asking me to repeat the pool liner example I gave. So that was explaining if the buyer and seller are in the counteroffer stage after the inspection report has been provided and the buyer's request has been made. If they're in the counteroffer stage and a buyer, for example, made a request for something to be repaired in their counteroffer, like a pool liner, and the seller didn't respond to that request within 2 days, that's the time frame they have. If they fail to respond within the 2 days, it's considered acceptance of the counteroffer. And it goes the same way if the seller was the one who initiated that counteroffer and the buyer didn't respond. Also, a question from Jan. If a buyer terminates a contract based on the home inspection contingency, but does not send the inspection report, does the agent, I'm assuming the seller's agent, does the seller's agent have to ask for it to see if there are material facts that need to be disclosed? No, there is no obligation or duty on the seller's agent's behalf to request and get a hold of the property inspection report. It's only if they're provided with it. You can't really just put your head in the sand and say and not read it and not potentially have to disclose material facts within the report. And kind of similar question from Bob, does the listing or does the buyer's agent, or are you saying that a listing agent, I need to give the inspection report to the prospective next buyer on a fall through? No, there's no requirement that you provide the full inspection report to a potential buyer. There is a requirement to disclose any material facts that were contained in the inspection report. Kind of a little bit of an off-topic question from Lisa here, or at least off-topic from what we've been talking about. If a buyer's lender cannot meet the settlement date, does that default the buyer if the buyer proceeded in good faith? So, no. Our financing paragraph in our contract of sale, I think it's paragraph 19, It specifically states that as long as the buyer diligently pursues financing and pursues it in good faith, if they are ultimately denied for that financing, or in this case, they miss the settlement date, as long as that is not the buyer's doing, the buyer's fault, then that buyer is not in default. And actually, we have specific language in the contract in that paragraph that states as long as the buyer diligently pursued financing and in good faith, then the release of deposit agreement shall state that the deposit will be returned to the buyer.
All right, well, that is all that we have today. So we answered 78 questions today during this hour-long webinar. Just a reminder that we do have our legal hotline open on Monday, Wednesdays, and Fridays. So if you have a more specific question, you can always contact us through the legal hotline, which is on our website, or call the office. And thank you so much for joining us today. Have a great day, everyone.
Thank you, everyone.
Is the webinar over? And conclude.
I don't know. How do we get out of here? I can't get out.
I'll just end it.